This is video BG1, ELLs and the law. Let's look at some of the brief history behind English language learning, starting with some court cases. Mendez versus Westminster, 1946. This ruling stated that school districts cannot segregate on the basis of national origin. This led to a little case you may have heard of, Brown versus Board of Education. How about Diana versus Board of Education, California, 1970? This case addressed the issue of assessment approaches and instruments. Keyes versus School District Number 1. This school desegregation case resulted in school district agreeing to major changes affecting the quality of services limited to English proficiency students. No longer could you stick them in the basement with 50 students, a desk, and a book and said, go learn. This one's trying to make it equal. Lau versus Nichols, a big one in 1974. This was a class action suit filed by the parents of Chinese children in San Francisco against the school district alleging that academic instruction was being provided in a language in which students were not proficient, hence depriving them of equal education opportunity. In Arizona, we see Flores versus Arizona Public Schools. This was where a parent alleged that the state of Arizona failed to provide instruction to ELLs that would advance their proficiency and enable them to master the standard academic curriculum. Which court case might be next? We also have to consider some of these. Title VI of the Civil Rights Act. Title VI prohibits discrimination on the grounds of race, color, or national origin by recipients of federal financial assistance. The Title VI regulatory requirements have been interpreted to prohibit denial of equal access to education because of a language minority student's limited proficiency in English. Title VII is a bilingual education act that recognizes the unique education disadvantages faced by non-English speaking students. All the complicated jargon basically says, we understand that some of these students are facing an uphill battle and we're here to help. Finally, Title III of the Elementary and Secondary Schools Act of No Child Left Behind simply provides assistance in terms of funding and staffing of ELLs. Some of the basics is the official state policy is to provide a 3-year transitional bilingual education program to its ELL children. You'll see the TBIP often, which stands for Transitional Bilingual Instructional Program. What are teachers responsible for? The legal protections for all students afforded to ELLs. As educators, you are responsible for all the students in your class equally. It doesn't matter if you're teaching history, PE, science, math, Latin, what have you. You're going to have ELL students, and it's your responsibility to treat them all equally. Who are these laws protecting? Well, you're seeing growing numbers of many, many different cultures coming into Washington schools, and as such, we have to have a way of knowing where to put them. This is where the WLPT or the WELPA come into play. The WLPT stands for Washington Language Proficiency Test. The WELPA is the Washington English Language Proficiency Assessment. Every time a non-English speaker, native speaker, comes into a school, they have to take kind of a brief survey type questionnaire. An important question is if a student answers yes to question 2, which says, is your child's first language other than English? If you say yes to this, you need to take assessments to be placed into classrooms. Remember, laws are not always enough. Beyond what is legal and illegal, remember who you are working with and how you would feel being in a new country, learning a new language. Be sensitive, challenge them, but at the same time be fair. What do you understand? Test yourself.